I want to mention three things for those of you who are watching at home on Zoom. First, you may wish to mute yourself so that your private conversations are not overheard and you can keep them private. Second, you may wish to turn your cameras off because all kinds of interesting things have been known to happen that don't need to be seen. Third, Zoom participants are invited to use the chat box to ask their questions, and we will present them at an appropriate time. Our February speaker will be the general manager of the Del Coronado Hotel, Harold Raposa, who's going to talk about the exciting things that are going down there and their recent business successes. We also have several future commitments that are interesting. The dates aren't quite certain for Tina Friend, who, is that a question?
Yeah, in as much as the speaker will be way away from everybody, would it be possible for the speaker to not be wearing a mask so we can understand?
The speaker will not be wearing a mask.
What?
The speaker will not be wearing a mask. Okay, thank you. We have a future commitment from Tina Friend, the Coronado City Manager, as well as Thomas Rayot, who's the Consul General of the U.S. Embassy in Tijuana. Now, John Jacobson will introduce today's speaker.
This one. Well, good morning, everyone. This morning's speaker is Judge Todd Robinson, who currently serves as a United States District Court Judge for the Southern District of California. And he's responsible for handling both civil and criminal matters. Before being appointed and confirmed to the federal bench, Judge Robinson was a senior litigation counsel with the U.S. Attorney's Office here in San Diego, where he handled many of the most significant criminal prosecutions filed in the Southern District of California. Prior to working at the U.S. Attorney's Office, Judge Robinson was a trial attorney with the Dangerous Drugs and Narcotics section of the U.S. Department of Justice in Washington, D.C. He also served as an operations officer with the Central Intelligence Agency. Judge Robinson is a graduate of the Georgetown University Law Center. And he received his undergraduate degree at the University of California, Berkeley, where he was also an NCAA All-American swimmer. He attended first grade through eighth grade in Tokyo, Japan, and then high school in New Orleans. Judge Robinson has received numerous awards over his career, the most prominent being the John Marshall Award, which is the Department of Justice's highest litigation-related award. So, ladies and gentlemen, please welcome Judge Todd Robinson.
Good morning, and I'd like to start out by thanking you so much for inviting me to give this presentation here today. All too often as a federal judge, we're stuck in our little world over in the courthouse, seeing people at low points in their life, if you will, when they come in and they're litigating cases. So it's both a privilege and an honor to just be out in the community, particularly in light of the pandemic, getting out and just interacting with folks in the community that we serve as federal judges is a privilege. And I want to thank you again for your invitation here to speak today. I am going to open this up for questions and answers at the end of my presentation, but I would encourage anyone both here in the room today and those who are listening on Zoom, if I say anything and it occurs to you to ask a question, just raise your hand and I'd be happy to answer any questions as we go through the presentation. And with your permission, I'm used to wearing a robe, but I'm going to take my jacket off just because we are all from California and we can be a little bit more informal. So please, as I go through the presentation, please feel free to ask any questions. I really want to interact with all of you and make sure that you come away from this having any questions or any concerns answered to the best of my abilities. As John said, and I want to thank him for that kind introduction, I spent 25 years as a federal prosecutor before being nominated by the president and being confirmed by the Senate to be a federal judge. And I thought we could talk today about the federal criminal justice system. And that's 50% of my workload as a federal judge. I have pretty much 50% of my time is spent on criminal matters and 50% is spent on civil matters. And I'd be happy to come back and talk to you about my civil docket and civil matters. But I want to talk a little bit about how a federal criminal case works its way through the system. And I'm going to talk a little bit about a criminal case, not only from the perspective of a judge handling those cases and what I am entrusted to do with respect to those criminal matters, but also from the perspective of law enforcement, from federal prosecutors, and from defense attorneys who play a very important role in the criminal justice system that we have here in the United States. And I would note that growing up overseas, I've had occasion to travel quite a bit, and in my professional capacity, also travel quite a bit and interact with individuals from other countries. And our criminal justice system here in the United States is an imperfect one, but it is the envy of almost every nation when it comes to, if you think about it for a second, the way in which we judge the guilt or innocence of someone is not an individual judge. It's not someone who may come to this with a particular bias or with a particular viewpoint on how things are or how things should be. It is based on 12 randomly selected people from our community that come together, they hear the evidence, they're instructed as to what the law is, and then in order to find someone guilty of a criminal offense, all 12 of those randomly selected people from our community must reach a consensus. They all have to agree and apply the standard beyond a reasonable doubt in order for someone to be held accountable in the criminal justice system for committing a federal offense. And the same thing holds true in the state system. Anyone charged with a crime in this country is held responsible if and only when 12 individuals from our community reach a decision that they are guilty by the standard of beyond a reasonable doubt. So if you step back and reflect upon that, the way that the system was created, it's incredible because people come into the criminal justice system, they're presumed to be innocent until such time as the government meets its burden of proving their guilt to the standard of beyond a reasonable doubt. And beyond a reasonable doubt, as many of you are aware, is a standard that is much higher than is applicable in a civil case, which is by a preponderance of the evidence, more likely than not, that is 51%. So beyond a reasonable doubt is a standard that is applicable in all criminal cases. But let's talk for a second about how a criminal case is initiated and how it makes its way into the federal system as opposed to the state system. Federal crimes in this particular district are by and large driven by our proximity to the Mexican border. A lot of our criminal caseload is derived from immigration offenses and derived from narcotic smuggling offenses that are coming to the federal system from the border. And that generates one type of case, that is a reactive case, a case where the crime has already been committed before the federal charges are filed. So what happens typically is you will have someone coming through the border, either someone who has been previously deported and excluded from the United States, coming back without permission to do so, which is an immigration offense. That person is apprehended, either coming through the port of entry under an assumed name, and all people coming through the pedestrian port are fingerprinted. So they're put into the system, and even if they say, my name's John Smith, the fingerprint comes back, you're really not John Smith, you're actually Joe Smith, who has 6 prior convictions and has been removed from this country 23 different times. That person is taken into custody. And it's a reactive case because the crime has already been committed. So the role of law enforcement at that point is basically to write up the offense, to take the person who's been arrested, process them into the detention facility, and to establish probable cause to believe that the person arrested has committed an offense. So they'll write out an affidavit and they will say the circumstances which led them to arrest this individual. That is, the circumstances that lead them to believe that there's probable cause. And that decision is not entrusted to the law enforcement officer, which is markedly different from some countries. The law enforcement officer must submit that affidavit or probable cause statement to an independent member of the federal judiciary. Those go to my colleagues who are magistrate judges. And we have a number of magistrate judges that will take that information, they will review it, and they will make a determination whether or not there's probable cause to believe that the person arrested has committed the crime. At that point, there's two courses of action. If the magistrate judge finds that there's probable cause, the person will work their way through the system. If the magistrate judge finds that there's not probable cause, that person is immediately released from custody, and there are no further criminal proceedings with respect to that individual. So the same thing holds true with drug smuggling cases that we see from the port of entry. Someone comes through in a car, a dog alerts to the car, the inspector, when they come through the primary inspection area, asks follow-up questions, notices signs of nervousness, notices anomalies within the car. I can assure you that those individuals who bring narcotics into our country from Mexico are limited only by their imagination. I can assure you that if there is a dead space in a vehicle, it has been used to smuggle narcotics into the United States and smuggle humans into the United States. We've had cases where individuals are being smuggled in the engine compartment of vehicles. Truly, believe me when I say to you, they are limited only by their imagination. And the price for being smuggled into the United States, in my experience as a sitting judge, is anywhere from about $5,000 to $20,000 per person are being paid to being smuggled across the border. And again, this is just through a port of entry. They're smuggled through maritime. We've had people with boogie boards being smuggled in a line around just right down here off of Imperial Beach when they come around. So there are numerous ways in which this is done. So that's the reactive case where the crime has been committed, law enforcement is alerted, and the person is arrested. The secondary type of case is the case that more often than not gets all of the public attention. And those are the proactive cases. And this is the difference between the federal system and the state system. In the federal system, the prosecutors and the law enforcement officers worked hand in hand to investigate crimes when there is a crime that is suspected of being committed, and they work together to develop the evidence necessary in order to apprehend those who are committing the crime and successfully prosecute those individuals who are committing the crime. So an example of a proactive case would be a multinational drug smuggling organization. You all may have heard of an individual by the name of Joaquin Guzman Loera, Chapo Guzman, who was recently extradited to the United States and prosecuted in the Eastern District of California and is currently serving a life sentence. I was fortunate to come to San Diego in 1995 to handle that particular case. They found a drug smuggling tunnel under the border that was still under construction. And the unique aspect of that particular tunnel was the plat maps down at Otay Mesa are off by a little bit. So they came across the border, they came up, and they were supposed to come up in a warehouse that they had bought. And they came up and they were looking at the warehouse a couple hundred yards off. And so they had to go back down and they were digging over to the warehouse at the time that the tunnel was discovered. So, they are ingenious, but they're not always perfect in the methods by which they use to smuggle narcotics and or people into the United States. So in a case of that nature, a proactive case, the federal prosecutor from the United States Attorney's Office will work hand in hand with the law enforcement officers who were handling the investigation. So that's when HSI, DEA, or the FBI become involved in the case. And you have all of those agencies that are entrusted with doing the investigations that result ultimately in either arrest or prosecution. or in the determination that there's simply not enough evidence to go forward with a prosecution. So the investigative techniques that are used in the proactive case range from the execution of search warrants to obtaining court-authorized wiretaps on individuals' telephones, closed-circuit TVs within places like this. So if this meeting were conducted on a monthly basis in order to further some sort of criminal activity, law enforcement could get a warrant and they could install in the corner a closed-circuit television that would monitor this criminal association and record what was going on. So again, those are the types of investigative techniques that law enforcement use in order to ferret out crime in the proactive sense. At the end of a long-term investigation such as that one, law enforcement officers will seek federal arrest warrants from the magistrate court again. So now we're back in front of the magistrate court, and the showing is going to be the same, whether or not there's probable cause to believe that the individual has committed the crime. And that can either be made by the magistrate court or an entity called the grand jury, which, like a petite jury, the jury that sits during trial, is a randomly selected group of individuals who hear the underlying evidence as the investigation is going on, and they have the ability to issue subpoenas. You may have heard that there was a special grand jury convened, I believe in Georgia, recently to look into certain activities of President Trump. And so in the state side, they can convene a special grand jury to do a particular investigation. But on the federal side, there are grand jurors that meet every single day of the week. So they have different panels. So there's a Monday panel, a Tuesday panel, a Wednesday panel, a Thursday panel. And if you're very unlucky to get selected, you're on the Friday panel. So the law enforcement officers and the prosecutors present evidence as it's ongoing to these grand jurors. They hear the evidence, and at the end of the presentation, the charges are submitted to the grand jury for their determination as to whether or not there's probable cause. Again, the standard is probable cause to arrest somebody and initiate the criminal proceedings. So that's the way that people work their way into the system. And once they're in the system, as you're all aware, the Sixth Amendment dictates that anyone charged with a felony offense is entitled to the assistance of counsel at all stages of the proceedings. So they will make what's called their initial appearance. You're arrested, you're taken into custody, you're booked into a holding facility. Within 24 hours or 48 hours, if you're arrested on the weekend, you make your initial appearance before the judge. So you come in custody, you're wearing your prison uniform, you are informed of the charges at that point. The judge tells you, you are charged with the following offense. Do you have the ability to hire an attorney? And oftentimes those that are indigent indicate we do not have the ability. And at that point, the court appoints them at no cost to them, an attorney to represent them throughout the proceedings. And in the federal system, we have two entities from which we draw upon to appoint counsel. The first is that there's an organization, a very fine organization called the Federal Defenders of San Diego. And they are solely tasked with representing indigent people who are charged with a crime. And they have a number of attorneys on staff that will come in and represent indigent people who are charged with a felony offense. The other group of people are a group of lawyers, and you can apply to become on the panel. And if you are a panel member, you are randomly selected as the court goes through the list to represent these indigent people. So oftentimes what the magistrate judge will do at the initial appearance is just bounce back and forth. One from the federal defenders, one from the panel, one from the federal defenders, one from the panel, until everyone who makes their initial appearance is given an attorney to represent them throughout the proceedings. At this juncture, the government has to make a decision as to whether or not the individual charged with the offense is either a risk of flight or a danger to the community. And so there was recently a ballot measure in California regarding cash bail. I'm sure you're all familiar with the state system. In the state system, there's actually a template. If you are charged with DUI, bail should be set at X amount. And if you're charged with 187, Homicide, bail should be set at X amount. And bail can be adjusted upwards or downward based on your criminal history and some of the extenuating circumstances. But basically, the consideration is in a chart form. It's not an individualized determination as to whether or not bail should be set. And the pros and cons have been sort of debated in the public arena, and it was submitted to the voters for their consideration. And that's a ongoing issue with respect to a number of different jurisdictions. And essentially, the argument against cash bail is that those who are without means, regardless of their ties to the community and the danger that they pose to the community, may be held without bail simply because they can't meet the bail that's set by this chart system. But in the federal system, the inquiry is a much different one. The inquiry is based on the danger to the community and the risk of flight of the individual. So the criteria that the court is looking at and being evaluated, does the person have family members here in San Diego? Do they have a job? Do they have an established relationship with someone that they can be with if they're released from custody? What is the nature of their offense? Is their offense one involving firearms? Is it one involving fleeing from the police when they were trying to be arrested? It's a very individualized determination that will be made by the court as to whether or not that person will be released on bond pending the resolution of their case. So that's a significant difference between the federal system and the state system. And the state system is tending to go the way of the federal system so that it's more of an individualized determination, which a lot of people feel is a more appropriate way of determining whether somebody should be released from custody, pending the resolution of their case. So once that determination is made, the government has the burden of producing what's called discovery in a case, which is all of the facts and circumstances surrounding the arrest of the individual, to include anything that happened during the investigation. So in a reactive case, the case from the border where we've got someone arrested bringing drugs in, being arrested coming in when they don't have a legal right to come in, the discovery material is fairly finite. It's the arrest report, it's any underlying investigation that was done, albeit somewhat limited. In a long-term investigation, it can be thousands and thousands and thousands of pages, because if you're up on a wiretap for 10 months, you probably have intercepted probably about 40,000 calls, and all of those calls are transcribed. The defense gets all of those calls that are all recorded. They're all recorded. And they're also, when the calls are being listened to by law enforcement, they generate what's called a line sheet, which is essentially whoever's listening to the call does a real quick summary of the call. Alberto talked to Maurice and they talked about delivering 10 of the same ones. That's going to be the line sheet. So it's incumbent upon the law enforcement officers to go, okay, 10 of the same ones, what are they talking about here? And they'll go back to, okay, historically, how have these guys interacted? And at some point, was there a traffic stop where somebody got 10 kilos of methamphetamine, and therefore it sheds light on what they're talking about, 10 of the same ones. But that's how they put together an investigation. And all of that material goes over to the defense. So of course they can prepare a defense to the charges. They are entitled to all of the underlying evidence in the case so that they can independently evaluate it and say, wait a second, the government put the wrong spin on this conversation. When they talked about 10 of the same ones as last time, my guy owns a catering business and I've got the receipts from 10 of the same ones. He's talking about 10 of the same, whatever, chicken plates or whatever, and he was delivering them for purposes of this wedding. And so they have the ability to evaluate that evidence and to challenge the veracity of law enforcement's interpretation of that evidence. And all of that takes place during the discovery process. Most of the cases that are filed in federal court are resolved by way of plea agreement. It's upwards of, I've heard low 90s. I'm sure it's at least in the 80s. 80% of the charges that are filed in federal court in the Southern District of California are resolved by the way of a guilty plea. So a lot of the cases when you hear trials going and so forth and so on, that is the unusual case that proceeds to trial. Most of them, once the defense attorneys take a look at the discovery materials and they have a chance to go over it with their client, they make a tactical decision that it's probably in the best interest of the person charged with the crime to admit their guilt. There's a benefit usually conferred upon the defendant by pleading guilty early on in the case in terms of sentencing consideration, but usually the cases are resolved by way of guilty plea. There is a motions practice, so motions can be filed by the defense attorney. So in the proactive case, I'm sorry, that I spoke of earlier, where law enforcement's doing wiretaps, you can only get a wiretap on a federal case. You see in TV, you know, they just like, oh, let's tap his phone. It doesn't work like that. There's a process that you must go through. If federal law enforcement wants to tap my phone, first they have to identify the phone. And there's a process to do that. Once they identify the phone, we go back to the concept of probable cause. Is there probable cause that I am using this phone to commit the criminal activity? I could be a well-known crook and I could be committing all sorts of crime, but you're not going to get an order to tap this phone unless you can connect this phone to the crimes that are being investigated. So in order to tap this phone, the prosecutors have to go back to Main Justice in Washington, D.C., and get a Deputy Attorney General's authorization to request the authority to tap this phone from a federal judge. So I assure you that that process does not happen overnight. So what they do is they submit the affidavit. It goes back for review by Washington, D.C. If approved in Washington, D.C. at Main Justice, then the Deputy Attorney General signs a letter saying, yes, you may seek approval. The wiretap package, including the probable cause statement, is then submitted to myself or one of my colleagues on the federal bench for independent review as to whether or not there's probable cause. If we determine that there is probable cause, by statute, we can only authorize law enforcement to tap this phone for a period of 30 days. And then they have to come back for reauthorization if they want to keep listening to it. And they have to justify it each time that they want to reauthorize that wiretap. So because of that process, when all of this information goes out in discovery to the defense attorneys in our criminal case that derive from the wiretap, they are going to scrutinize whether or not all of those procedures were followed properly by law enforcement. And if they find a defect in the procedures, they will file a motion with me to suppress the wiretap. And if I find that they did not comply with all of the statutory requirements, I am under a legal obligation to suppress the wiretap. And by suppressing the wiretap, that means that law enforcement cannot use anything obtained via this wiretap that was defective in some way. So that's the motion practice. And the same thing would hold true if they did a search warrant at the suspect's house. And the probable cause statement, again, the probable cause to get a warrant, if there was a defect in the probable cause statement and whoever the authorizing judge was made a mistake and should not have authorized that wiretap, much like the bad wiretap, any evidence found during the search pursuant to that warrant would similarly have to be suppressed under the state of the law. So that's the motion practice that would occur before me as the trial judge. And I would be entrusted with making those decisions as the case goes along. Now, if the case goes through, so the defendant doesn't want to plead guilty, all of the suppression motions are denied, every defendant is entitled to their day in court, right? And circling back to the 12 randomly selected people from the community, we would set the case for a jury trial. There is a Speedy Trial Act which requires every defendant charged with a federal crime to go to trial within 70 days of being charged. As you can imagine, producing the discovery material, going through it, filing those motions, very few cases go to trial within 70 days of the actual charges being filed, because that 70-day time period, there's like a pause button. Every time there's a motion, that clock stops running on the 70 days under the Speedy Trial Act. So in the Southern District of California, I recently learned nationally, it's my understanding that each district court judge nationally handles approximately 115 criminal matters a year. I think currently we have 240, more than that. I'm sorry, Jessica, my courtroom deputy, is here, and she knows exactly how many. But we've got at least twice that many in the Southern District of California. So we are in an incredibly busy district. We do everything within our power to ensure that the busy nature of our district does not adversely impact any defendant's right to go to trial in a timely fashion. Because think about it, you've got someone charged with a crime. They're presumed to be innocent. If a magistrate judge has made a determination that they pose a risk of flight or a danger to the community, they're doing time in custody pending the resolution of their case. And so there's a strong incentive to get that case to trial as soon as possible, so they have their day in court, so they have the facts considered by 12 people randomly selected by the community to ensure that if they are incarcerated, that determination is made as soon as possible. Because of the presumption of innocence, we do not want people sitting in custody longer than absolutely necessary to process their case through the criminal justice system. So in the unlikely, well, not unlikely event, but given the statistics, it's somewhat unlikely event that a defendant is going to go to trial, we bring a panel of jurors in. Depending on the nature of the case, we will send out jury summons for anywhere from 80 to 100 people for a jury to have a panel of 40 jurors that go into the actual courtroom itself. And what happens during that process, just a show of hands, has anybody been through jury selection? Okay, thank you. Thank you for your jury service. We're gonna pick a jury on Tuesday, and I always thank the jurors because the criminal justice system that we have would simply not work without the willingness of people from our community to come in and perform that incredibly important civic duty. I can't tell you how appreciative I am as a federal judge and my fellow colleagues are that people are willing to set aside all of their obligations that they have to come in and perform that incredibly important civic duty. And I have a special place in my heart for jurors because I was selected as a juror several years before I took the bench. And I know what an imposition it is. I mean, you always sort of know because they're there, but I know what an imposition it was. And at least in my courtroom, we do everything possible to ensure that the jurors who report for duty, we use their time in the most efficient manner possible. No sitting around, no waiting. If you're in the courthouse, you're hearing evidence and we're using your time efficiently. So for those of you who raised your hand, thank you very much for your jury service. And for those of you who didn't raise your hands, when you get your jury summons, we look forward to seeing you in the federal courthouse. Again, during the jury trial process, the government has the burden of proving each and every element of the offense to the standard of beyond a reasonable doubt. So they have to introduce the evidence. The defendant has to do nothing. A defendant could theoretically sit there and do absolutely nothing, and only until the government introduces sufficient evidence to convince 12 people beyond a reasonable doubt that the defendant has committed a crime, that defendant is free to go until the government meets that burden. So it is the government's burden to do that. And from a judicial perspective, you may have heard during some of the confirmation proceedings, particularly with respect to Supreme Court justices, because they get a lot more airtime. Oftentimes it's referred to as calling balls and strikes as a judge. And, you know, I don't think that that's an unfair characterization of what we do as judges. We rule on objections. There are rules of evidence that govern what can come into evidence and what cannot come into evidence. And to the extent that a party feels like the opposing party is trying to do something not permitted by the federal rules of evidence, they will lodge an objection. And as the trial judge, you either sustain the objection or you overrule that objection. And if you sustain the objection, the evidence does not come in or the question is not answered, If you overrule the objection, the question must be answered by the witness, or the evidence will be received and the jury can properly consider it. So that's the trial process. At the end of the case, it is also my role in the process to instruct the jurors as to the law which governs their deliberations. And reasonable minds can differ as to what the law should be oftentimes. We have robust discussions in this country about the existing immigration laws. We have robust discussions about the drug laws, and as we should. That's what the First Amendment guarantees and what society demands of all conscientious citizens, to think about these issues, form an opinion, express that opinion, listen to other people's opinion, and we can have a robust discussion. The time to have that robust discussion is not in the jury deliberation room, though. If you come into the case and you feel like all drugs should be legalized, that's covered during the jury selection process. You are not to lie in wait and then go into the jury room and say, I don't care what the evidence was. I'm going to disregard the law that governs the deliberations in this case. And there, under no circumstances would I ever convict anybody of any drug offense, because I just don't believe in the drug laws. That's not your role as a juror. And the flip side to that is true too. You cannot, under any circumstance, go into the jury room and say, I know exactly that type of person. I knew him growing up. I knew him as an adult, and I don't care what the evidence is. He's guilty of something. Maybe not this, but I'm going to find him guilty, right? That's the flip side to the mindset, which is clearly impermissible. And that's what we try to ferret out during the jury selection process. Anyone who would take that type of an approach to their discharging their duties as a juror in any particular case. So the jurors go back. They're given all the evidence that's received, with the exception of firearms and narcotics. We tend not to send those back to the jury room. I found that that's a really bad idea. But they, based on all the evidence that they've heard, they reach a consensus if at all possible. If not, we have what's called a hung jury, and we do it all over again. So we do everything we can to encourage the jurors to engage in a discussion and to listen to their fellow jurors, appreciate their positions, and try to reach a consensus if at all possible. If not, sometimes it's just not possible. We declare a mistrial and we do it again if there's no resolution of the case. So that is the life of a criminal case in the federal system. Of course, there are appellate issues. Anyone convicted of a crime has the absolute right to appeal any decisions that I've made throughout the course of the case to the Ninth Circuit Court of Appeals, and have another day in court and revisit any of the rulings that I've made as the trial judge as we go through the case. So there's a whole separate appellate process. Theoretically, it could make it to the Supreme Court. I've had no case go to the Supreme Court. If there's usually there has to be a split among the different judicial circuits or some other reason for the Supreme Court to take it up. So that is the life of a criminal case. I think I have made it 2 minutes shy of my allocated time. And I would encourage anyone to ask any questions that you have, either specifically on topic or off topic that you might have as a
First question.
Thank you.
Is from Zoom.
Okay.
Question from Zoom.
I'm